Hello and welcome to the Rogers Brief for October 1st, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. Those that were watching last week's video will know that I had a little procedure done, had some stitches there. Those have been removed, so getting back to normal. Hopefully that's not distracting to anybody watching this week's video. Some interesting stories this week to cover, but before I get to those, just some other smaller things. Announcement came down Friday from the CRTC that podcasts are going to have to register or be registered with the CRTC on a go-forward basis. So I was looking at that, wondering if this podcast, such as it is, I do broadcast this in podcast form as well as on YouTube, you're going to have to register. Not yet is the answer. You have to have over 10 million in revenue before that kicks in, so not there quite yet. Another thing today, the Sunday night show usually goes Sunday night with Jordan Bonaparte as the host, Paul Palango and I as guests. That's not happening tonight. That's going to be on hiatus this week. Watch Jordan's nighttime social media feeds for updates on that, and I'll echo that as well. And big international news, big news out of the United States. There's some legal news. Legal news out of the United States usually means a former president or the son of the current president. This week, the big legal news out of the U.S. was an old case. Tupac Shakur's killer, or one of his killers, arrested this week. Duane Davis, a 60-year-old man lives now in Las Vegas and was in Las Vegas in 1996 as well when Tupac Shakur, rap star, was shot and killed. And something fellow probably shouldn't do. Duane Davis in 2019 wrote an autobiography called Compton Street Legend. And in that autobiography talks about how he was in the car that where the shots were fired that killed Tupac Shakur. Drive-by shooting. He handed the gun to the shooter, who he named. That shooter is now deceased. Has died a couple of years after the 1996 shooting. So cold case. Finally getting some answers on that. So we'll keep an eye on that as the case unfolds. More local news, Nova Scotia news. 2 new judges appointed this week in the Provincial Court. One being Alonzo Wright, who was, until his appointment, the head of SIRT, the Serious Incident Response Team, the organization that examines the behavior and opines on the potential criminality of any behavior on the part of police officers. And so now he was new to that role, in there less than a year, wrote a few decisions, some controversial. He had gone after the Halifax Examiner for writing an article, which was an accurately written article. So going in with some mixed reviews in his job at SIRT, but previous to that had a good reputation as a Crown prosecutor and was involved in lots of committees and other things. The other judge named this week. But I guess before I talk about Judge Heerema, the other judge is easy to talk about. Judge Mark Heerema named. He was a public prosecutor as well in the specialized division in Halifax. Looked after some bigger cases. Although I see as well some commentary this week after his appointment that he was the Crown lawyer who put up quite a few obstacles for the media in accessing information from the Information to Obtain from Gabriel Wortman's, the search of Gabriel Wortman's property immediately after the mass shooting in Nova Scotia. And the province, the government, restricted what the public could see from the ITO, the Information to Obtain, which is all of the investigative detail that goes into an application for a search warrant. That was all sealed, and he was the lawyer that was arguing on behalf of the province to hold that in abeyance. It was all eventually publicized in one form or another through the Mass Casualty Commission, I questioned at the time what the province's strategy was there, because it was clear that eventually all this information was going to get out. Why not release it right away, as they do in other jurisdictions? Certainly in the United States, that information would have almost all been public right away. So some questions there, but a good reputation otherwise, from what I understand, talking to some other lawyers that know him better than me. Alonzo Wright's appointment, probably well deserved, but the SIRT appointment is supposed to be a 5-year appointment. And so, question in one respect why he would apply for a judicial appointment while accepting a 5-year appointment as the SIRT head. The other thing what it does, though, is undermine the usefulness, in a sense, of the SIRT team, because there you have the leader taking off very quickly, changing in leadership, changing in the decision maker at SIRT, and now there's an interim head of SIRT, Aaron Noss, who's a lawyer I knew back when I was articling, so that's 18, 19 years ago, has been involved helping out with the investigations with SIRT, and is now the interim director. So we'll see what happens there, but not good for the oversight of police process in Nova Scotia to have so much turnover in that important position. But 2 new judges now. The Provincial Court is at a full complement of judges, and so hopefully that means better access to justice in Nova Scotia, and fewer cases going by the wayside. Like we've seen cases in recent months where delay has been a factor, where the cases have been stayed or just withdrawn based on the delay and the unavailability of judges to hear certain cases. Okay, so those are just some of the warm-up stories that caught my attention this week. The ones I want to talk about more in depth would be these. One, the Mass Casualty Commission's, the Progress Monitoring Committee set up to monitor the implementation of recommendations from the Mass Casualty Commission met this week. I'll talk about that. The Nova Scotia government, and somewhat related, I guess, has issued a tender, a request for proposals for a comprehensive policing review. They're looking for a consultant to take on that role. They've also, the government has issued an announcement saying that they're going to undertake a Freedom of Information review, a review of the legislation for freedom of information requests in Nova Scotia and how that system works or doesn't work. The next story I'm going to talk about is out of Cape Breton, Sydney. This is in the news this week. The fire chief of CBRM, Michael Seth, has resigned and is moving back to Ontario. And in the course of the resignation and some of the fallout, we have learned about a harassment complaint that he made regarding 4 municipal councillors and an issue of Canada Day celebrations back in the summer. So I'll talk about that report. A questionable report came out on that. And finally, I'm going to talk about the Saskatchewan Injunction hearing on the education policy parental rights issue that's gaining some traction, some momentum, getting lots of attention certainly across the country. And in 2 provinces, Saskatchewan and New Brunswick, court action has been taken in opposition to these policy proposals, policy implementation in Saskatchewan's case. And so last week I talked about how the applicants there had asked for an injunction on the policy pending the final resolution. We have a decision on that injunction and a very strong reaction from the Saskatchewan government. So that'll be the last story I cover here today. So let's go through them. First, the Mass Casualty Commission Progress Monitoring Committee. This is the committee. There are 16 members, members from the government, policing agencies, municipal representatives, family representatives, and chaired by a retired Court of Appeal Justice Linda Oland. This committee is to monitor what happens. They are not a committee that can order anything to happen. They are to meet 4 times a year and then report on an annual basis, I believe, although I can't imagine they won't report something every time they meet. about what has taken place. Now, I say that they had apparently 2 days of discussions. Reading the newspaper articles on these meetings, 2 days of discussions, and we really didn't learn anything about these 2 days of discussions. And there's a reason for that. There's a couple of reasons for that. One is it's the first meeting, and maybe they just didn't want to talk about what happened. The only thing that we heard from Justice Olin was that the family, she was complimenting the family representatives for how calm and professional they approached these difficult situations. So reading between the lines there, it sounds like there might have been some heated moments behind the scenes, or not behind the scenes, behind closed doors in these meetings. Noteworthy that it has been 6 months since the Mass Casualty Commission issued its final report with 130 recommendations, and I think anybody watching this even casually would say that there's not exactly been a blistering pace of implementation of those recommendations. Can't think of any in particular that have stood out as being implemented, or even really serious progress being made on them. The RCMP announced, or somebody from the RCMP indicated, that there would be an update on their website on Friday, 2 days ago, of the progress they've made as an entity that was subject to many of the recommendations. That was not on the website. Their website's having some issues. I'm not sure exactly if they are related to the update not being there, but the RCMP website, if you go to it, as of this recording, midday on Sunday, is not operating. There's no news on there. So, something to watch. Problem with this committee is that everybody's signed confidentiality agreements, and so therefore there are two related problems. One is the committee is supposed to operate on consensus, so everybody's supposed to get together, even though they have diametrically opposed positions on many of the issues one can imagine. So that's going to be difficult. And then the second part is that everybody signed confidentiality agreements, so they're not supposed to talk about what happens during the meetings. So there's going to be some serious disagreements. We're not going to find out about them. There'll be some updates, I suspect, from Justice Oland during her 1 year. She's already halfway through her, well, I don't know if she's halfway through. She's months into her 1 year commitment to head up this committee. And we really don't know anything about what the committee has discovered or what has been implemented as a result of the recommendation. So we'll keep an eye on that committee and see. Their next meeting is in December, so we'll see at that point if there's any further or significant updates. Okay. Next is related to this. One of the recommendations was from the Mass Casualty Commission was that a comprehensive policing review take place in Nova Scotia. We have a patchwork of municipal forces. Rural areas are policed by the RCMP on contracts, some collectively through the province, some individually by municipalities contracting with the RCMP directly. And so what should happen is the question. The Mass Casualty Commission covered this in great detail, talked about how policing operates in Nova Scotia. I've covered this myself. And so now the province has released a request for proposals for consultants, management consultants, policing management consultants in particular, people with experience in the area, to propose a review of the policing in Nova Scotia, a technical and comprehensive policing review. So the proposals are due by the end of October. The estimated duration of the project is 16 months, which would take us to the spring of 2025, more or less, which is just before the next scheduled provincial election, which is scheduled for July of 2025. So what's going to happen? This comprehensive policing report will come before be delivered to the government, or delivered to the Minister of Justice a few months before the election. They'll review it, consider it, think about it, and then do nothing about it, certainly before the election. So we're not going to get any policing changes in Nova Scotia very soon. Whatever the next election is about, if it's provincial, if it's going to be about healthcare, if it's going to be about housing, This policing report will be available. We'll see if the parties take any view or different views on that, but we won't know that until just before the next election, really just buying time. So interesting to compare that review, that upcoming review, to the other one the province announced, which is a review of the Freedom of Information system in Nova Scotia. Again, this is a justice issue. Same deadline as the policing review, just before the next election. So again, the government will go through this mandate after having promised to make changes to how freedom of information works. They'll go through their first mandate. I know they're hoping for more than one, without any changes taking place to freedom of information. The big issue in this is whether the commissioner, the freedom of information head, can make orders. The privacy commissioner now is not empowered to make orders. They can make recommendations to the government, which the government can ignore. Then, if the government ignores that recommendation, the person that wants it needs to take the government to court over it. Certainly the recommendation from the privacy commissioner is used as evidence to bolster any argument before a judge, but it's expensive, it's time consuming, and very inefficient. Uses up judicial resources, court resources, which could be saved if the privacy commissioner had order making powers. Government looks at it and says, well, we don't really want the privacy commissioner to be ordering us around. They'd like to hold on to some of more of that power, make it more difficult for people to get that information, it seems. So we'll see. Okay, so compare the two processes, the two reviews upcoming. One, the policing review. This is going to be done by an external consultant, whereas the Freedom of Information review is going to be done internally. An internal committee. They'll consult people outside government, but it's going to be an internal report. And so one would presume that whatever comes out of that report is going to be what the government wants to do and is likely to be implemented. The policing review strikes me as something different. I think the government looks at this as not just an isolated policing review, but politically thinking, well, they're not sure how that's going to poll, how the public is going to feel about this. And so I think they're more comfortable having an external report, which they can either adopt if it seems to be getting a good review from the public, or they can disavow if the report comes out and there's negative public reaction to it. So it gives them an extra little buffer layer, whereas the Freedom of Information review, I think they're probably going in knowing more or less what they want to get out of it, and they're going to just sort of take the time to get there. So two reviews that we'll have in a year and a half or so, more or less. Okay, next story I want to talk about. Really interesting issue out of CBRM, Cape Breton Regional Municipality. So heard a week and a half ago, a couple weeks ago now, the fire chief had resigned. Michael Seth, who's a Mohawk from Ontario, fire chief, had been hired a few years ago, came to Sydney, head of the CBRM fire department, left under not a cloud, but there was some questions about why he was leaving. And then it comes out that there was this harassment complaint that he made back in the summer after consulting with the mayor. Evidently, we see there's a report that it got issued, so we know some of these details now. Consulted with the mayor and made a harassment complaint against 4 councillors. None of these 4 councillors spoke to Michael Seth directly, and none of the subject matter of the complaint related to anything fire related. Nothing to do with the fire department, no comments were directed towards Michael Seth. Here's what the issue was. There was a staff member from CBRM was on CBC radio in Sydney. Joe Costello was the staff member, saying that July 1st celebrations, this was just before Canada Day, July 1st celebrations, well, let's just call them July 1st celebrations for now, because that's the issue. We're not going to be called Canada Day. They were going to be instead called Night of Lights. Now, it wasn't the whole day wasn't going to be, like Canada Day wasn't going to be not used at all, but the evening element of those celebrations were going to be called Night of Lights. So, some constituents got in touch with Councillor Darren Bruchschwager, who emailed staff and council and said, what's going on here? Who canceled Canada Day? And then there was some follow-up emails in a couple of email threads, and other councillors, Ken Tracy, Erlene McMullen, and Gordon MacDonald, all chimed in with different comments as well, saying this is... So I read the comments. They're all in this report. So I'll get back to the comments in a second. So procedurally what happens is Michael Seth made a harassment complaint through the process, which takes it up to the CAO, Marie Walsh. Ms. Walsh contacted a law firm in Halifax, Stewart McKelvey, and they prepared a report. And the report was done by Catherine Mack, a lawyer at Stewart McKelvey. 2020, called to the bar, so 3 years in to practice. Not very long, but a specialist in employment law and a good... She had some scholarships before she became a lawyer, so she's not just anybody, but only 3 years in. 27-page report found that there were low-end breaches of the municipal harassment policy. No sanctions were handed down. The councillors were, it was recommended that the councillors engage in some education, some sensitivity training. None of them have done so, and have more or less rejected the need to do so. So a report without a whole lot of teeth, and that was one of the criticisms that Tom Urbaniak, political science professor at CBU, who was quoted in the CBC article, made about this, that really should have been done under the Code of Conduct policy. My view is that it shouldn't have been done at all. You read these emails and there's nothing to it. Darren Bruchschwager said, who canceled Canada Day? Well, that was what the interview basically portrayed, that from the staff member Joe Costello, was that they were not going to use Canada Day, the words, in their celebration on July 1st. So, all right, that wasn't unreasonable. Erlene McMullen said it seemed ridiculous. Ken Tracy, I think, said, or Gordon MacDonald said something to, Erlene McMullen said, yeah, Canada's not perfect, but it's still worthy of celebration. Ken Tracy said something to the same effect. Gordon MacDonald said this is, it's an insult to our veterans and all this stuff. Anyway, all of these emails were on an internal email thread just among councillors. Now, so that raised one question: are these emails a public forum? And the answer to that seems to be yes, because you could gain access, or you could see these emails if you made a Freedom of Information request. So that makes it public. It's not quite the same as being in an open meeting, but it's close enough. So that's it counts as public. Big problem for me, well, there's a number of things. First of all, how insensitive were these comments? It was, an open question as to whether Canada Day should be celebrated, and seems like you should be able to discuss that in some way. And there was nothing particularly offensive about the comments. So harassment under the policy is behavior that a reasonable person would find unwelcome, and it must be related to a prohibited ground. So I think they found in this case that it was related to ethnicity, so you can make that connection, of course, that people that were of Aboriginal descent may have been offended by this, and there you go. The other question, but the question at the core of it was, from the councillor's perspective, is this is a major decision to change the celebration and not use the Canada Day reference. And is that a decision that staff should be making, or is that a political decision? Is that an operational decision or a political decision? And the thrust of it, the emails from council was, we should have been consulted about this. This is a decision we should make. Who's making these decisions? Is there a staff committee? What's going on? Those were the sort of the main points of their emails. And, I think if it's a fair question as to whether Canada Day should be called Canada Day, if you want to have a discussion, you have to be able to have a discussion. And I think calling it harassment to even engage in the discussion is taking things too far. Anyway, that's what happened down there. It was anyway, unfortunate to see somebody resign with hard feelings, but don't think that should have been harassment. And the report from Ms. Mack didn't really get into, I guess, the philosophical question as to whether political, like elected councillors, can get into a political discussion over email. It seems like they can. All right, last thing I want to talk about. This is a big, important national issue right now. And this is the issue of parental consent, education policy. Can children under the age of 16 use their new pronouns, use chosen names, quote unquote, for anybody that is having some questions about their gender, or is gender fluid, or is transsexual and transgender, and so can they go by their new names and pronouns in school, or must they have parental consent before that happens? So it's come up in New Brunswick. Talked about this before. The Canadian Civil Liberties Association has challenged the law in New Brunswick. It came up in Saskatchewan as well. And last week there was a group called You Are Pride out of Saskatchewan, out of Regina, put together a case and is opposing the new policy in Saskatchewan that it's a breach of the Charter, it's a breach of human rights, and a number of other things. And in addition, they did something that they didn't do in New Brunswick, which was ask for an injunction against the enforcement of the policy pending the final outcome. And so I talked about this last week, and I was expecting that a decision would come fairly soon on the injunction question. It came sooner than I thought. It's already out. It came out this week, late this week, and the judge, Michael McGaugh, gave a quick decision, but a very thorough one, 56 pages long. Talked about the injunction, and to me, reading through the case, which I did, it was a very easy decision from the sounds of it. It was a very clear decision. So, an injunction is not always something that you seek in a case, but you can, if you can show that there's a serious issue to be decided. That's a low bar. Most cases have a serious issue to be decided. Second one is the tricky one. You have to show that there is irreparable harm to one side or another if the injunction is not granted. And then the third thing is to balance all the factors and make a decision. Well, when you read through the decision, the UR Pride side, the applicants, had 3 or 4 experts, Canadians, from Simon Fraser, from I think University of Victoria, and they spoke directly to the issue and the harm that could befall these young students if they're, forced into misnaming, misgendered, being misgendered at school, and not having any support through the school. The government's so-called expert, I guess they were qualified as an expert, it was somebody from the United States, from the University of Berkeley in California, and their expert did not engage the core question. The core question in the injunction was, would there be irreparable harm to a 14 or 15-year-old student who wanted to go by a new pronoun with a new name, couldn't tell their parents, couldn't get parental consent? Would there be potentially irreparable harm? The government expert didn't even address that question. So all their report said was that it is good if you are in that kind of a situation, if you're the kid in that situation, It would be good if you had parental support. It would be good if you had counseling and some guidance as to help you through it. Well, of course, but not everybody has that parental support, or even, parents that might support you. And that wasn't really the point. The point was the opposite. What would happen if you had to be misnamed and misgendered at school? The other part that was clear in the decision was the government took like a few days to do this, to make this policy. Did not consult anybody, did not consult any experts, did not consult anybody that might be affected, didn't talk to the schools. So it was really, I suspect the only people that consulted were pollsters to say, this is popular, go ahead and do it. Some people are loud and outraged about this, so you should do it. In granting the injunction, a couple of the other factors the judge noted was that there's going to be a very small number of people affected. All right, so it's not going to be a rampant, it's not going to be all over the place and everybody coming home and being mysterious. A very small number of people affected. And the second part was that the hearing itself, the main hearing, is going to come before the end of the first semester. The hearing is going to be in November, probably get a decision before, in December, January, before the end of the first semester. And so the limited effect of the injunction. Whereas on the other side, so if they're doing the third act, the third part of the test, the balancing of convenience and harm, only a few months of, properly from the child's perspective, gendering and naming them, versus, a few months of keeping a few parents in the dark, fell down very squarely on the side of granting the injunction. Premier Scott Moe has made a very dramatic has had a very dramatic reaction to this, and this I guess was predictable. He talked about using the notwithstanding clause. The notwithstanding clause, for those that aren't engaged in the Constitution very often, it's in the Constitution, and it says that governments may enact legislation notwithstanding that it is a violation of some part of the Charter. It could be a violation of equality and some other rights. So you can do this, and governments do this. Used to do this more often. It was mostly done by Quebec on language rights. It's been used a few other times, the notwithstanding clause. Supposed to be a fairly rare thing, but it doesn't have to be. The unusual part here is that it's only an injunction so far. This is a temporary ruling by the court, pending the final outcome, which will be coming in a few months' time. And yet, Premier Moe and the government have decided that this is important enough to use this very dramatic tool, the notwithstanding clause. So that's unusual in itself. Second part of the problem is the government barely advanced an argument in the court case. They have a very weak argument. They're if they wanted to say what they really want to say, which is people seem to be scared by this, so we thought we'd put a policy in place and people seem to like it, that wouldn't be enough. That's just not going to work in court. And they've really not advanced much of an argument on the substance of the issue. And then the third part is the purpose of the Charter and the equality and all these provisions is to protect vulnerable minorities, not parents, not voting parents, not anybody else that's just not used to something, or a little scared of, or being deliberately scared by people that have an interest in the outcome. So seems to me a very improper use of the notwithstanding clause, premature, and taking it way too far at this early stage of proceedings. But what I talked about last week, and I think it holds, is that if you followed through the thread of the decision and the thinking from Judge McGaw, which I think will hold up to an appeal, which I think will also be echoed in the New Brunswick case, we're seeing now that the courts are going to look at this a certain way, that yes, there is harm, and so I guess on the substantive issue of misgendering and needing parental consent, the signal seems to be that the courts are going to go in the direction of, allowing those children to have some freedom to talk to teachers, not necessarily need parental consent. I think any of these policies that are brought in across the country are going to be struck down as unconstitutional and charter violations. So we'll see. We'll see if other provincial premiers bring in the hammer that is the notwithstanding clause, like Premier Moe is threatening to do, and we'll see what if he actually follows through on that. So, all right, longer. That was longer than I intended to discuss some of those things, but that's fine. I hope everybody enjoyed the video this week, and we'll be back next week with some developments with some of these stories I expect, and some other new court decisions that are coming along. Some things out of the Supreme Court of Canada are coming out as well, so we'll watch for all that, and we'll be back. So till then, thank you for watching, thank you for listening, and we'll see you next time.